Welcome everybody to the Hospital Issue Notices of Non-Coverage HINNs webinar. I'm Tom Ryan and I'll be your presenter. Today I'm joined by Leanne Foster. She's from my team and a friend of mine. She's going to help me with technical problems and guide me through the question and answer sessions that are put live into the chat. So once again, did you catch that? Live in the chat is where you're going to put your questions. I will tell you we did have some pre-submitted questions. I will go through those first and then do the live questions second. Let's move on. Got to go through a bit of a disclaimer just to remind you guys for some stuff about this education material. First, this education is designed to assist you. The information was current and accurate, but if you've been with Medicare for more than a few minutes, you know that Medicare tends to change. Now, these are through the rules, laws, regulations. These official guidelines are posted on the Center for Medicare and Medicaid website. This is cms.gov for providers, and you are welcome to look at those at any time. Anything posted on that website will override any information in this educational presentation. I will provide responses to questions based on the facts given. Keep in mind, the Medicare regulations will always override my response, and information not given, presented, extra, removed, whatever you want to do with that question, it can change the response that I would have given. So I'm only going to be held to the information that was in that question. So I'll ask for clarifying things. I'll say, hey, put that in chat. I can get back to you, different things like that. Last thing, CMS does prohibit the recording of this presentation by you, the provider community. We don't know who you're going to use it or how you're going to use it. So because we don't know how you're going to use it, if it's for profit-making purposes, we just simply ask that you don't use it. What we will do instead, and you heard me say this, I'm going to start a recording. That recording will then be posted to our YouTube channel. The YouTube channel has an Encore playlist, and it will be available inside that Encore playlist. It also has a couple other ones specific to billing on the UB04, 837I, and this, and we'll put them into that as well. So please make sure that you're aware of where this will be posted. Presentation will be available for 60 to 90 days on our website as well, but after that you'll have to email us and ask us for it. What's our objective today? In the different forms, our goal is to understand the different forms and when to use each one of the different forms. With that, we're going to give you a little background. Now the background is more than just here's what it was or here's what it is. It's going to talk about some basics and some general information you need to know. We will then move through each one of the forms, and last I'll provide you with a few resources. Now I say and last, but I do tend to go through the resources as I come to them. So please, if you need me to stop, go through a resource, show your resource, throw it in chat. Leanne will let me know so that I can get to that versus trying to come back to it later. Now there are things I will go through at the end, hopefully if I miss them throughout the presentation. Let's go ahead and we're going to start with the background or the overview. The part of this that is really important is to build for those people that had some really basic questions. So hospital issue notices of non-coverage and what do you need to know? I want to get the general information because if you don't understand that, then you won't get into some of the detailed information, and also the four notices won't make sense. So we want to make sure you have that really generalized information. All right. So the purpose of the hospital notices is to inform the patient of items or services that are not medically necessary, not delivered in the most appropriate setting, or are custodial in nature. So the patient must be eligible to bill Part A and Part B. If the patient does not have eligibility for Part A, then these forms don't apply because they don't have any billing purpose for that. If they're not eligible for Part B, then you cannot bill certain services to Part B. So when we look at this, really the goal is to help the patient understand why Medicare won't cover something and their financial liability during that process. It also then provides them with rights. These rights explain what they can do if they disagree and think Medicare should continue to cover it. So that's really the basics of what you're doing with these notices. You're helping the patient understand Medicare coverage. Now you say, okay, but isn't the patient responsible for understanding that? Yes, they have to understand that Medicare covers not medically necessary services. But what is defined as a not medically necessary service? That's defined by the medical professional or the facility providing those services. That's who you represent. That's why you're supposed to be responsible for giving them this information. It again helps them understand and what rights they have if they disagree. It'll also help them understand their financial liabilities and sometimes for a not medically necessary service that may be a driving factor for a patient, okay? Now, the different forms are designed differently to be used at different times with different situations of not medically necessary services. And that's what we're going to go over. So we do want to make sure that you are aware that there's also patients who have Part B coverage. Now, what is Part A coverage and what is Part B coverage, and why is this important? For this purpose, Part A coverage is your institutional inpatient care, and that's what these forms are used for, inpatient hospital. However, Part B coverage does continue. Now, Part B coverage, if a person is eligible, what Part B coverage will do for you is give you some coverage for services that would be covered if they were in an outpatient setting as well. So if Part B would normally cover it, a hospital, even though they're inpatient, can bill those Part B services, and the patient may or may not be liable. And we'll talk more about that in just a few moments because there's a separate form for that. So really our basics are, one, to tell the patient when you as the provider will consider a service not medically necessary, when an ordering provider may not, all of those different types of situations. Give them their rights. Do they agree with that? Do they want us to consider it, being us or another form of Medicare entity? And are they willing to accept that financial liability? That's the goal or the purpose of this form. Let's talk about some of the basics of the form though. One of the key things is these forms must be completed in advance of presenting them. This was a question that was asked, and the question was, can we complete this as we present it and as we're talking to the patient? And the answer is no. You can explain it, you can go over the details, you can help them understand it, you can refer them to 1-800-MEDICARE, but you can't complete it. Also, you have to use the correct form. And that's why I keep mentioning that there are multiple forms, and we will get into that in the next section. So you want to make sure you're going to use the correct form for the situation that that patient is in, because it's not an all is equal to one thing situation. In other words, not one form for everything, we're good, we're to go, and we're done. There are 4 different ones. One of the basic key components is explaining it. One of the questions was, does the patient have to be able to understand it? And the answer is yes, the patient does, or a representative does. Key thing there, a representative. So we'll talk more about that when we talk about signatures, because those representatives would also then need to sign saying they got the form. So I'll explain that on the next slide where it's actually built in. Now, comprehend, what does that mean? In the situation that was provided in the question was very clear. They needed an interpreter because the patient did not speak the same language. That is part of presenting the form. It is not an additional payment. On the other hand, it's part of making sure this patient understands it, so you do need to have that. Medicare says you cannot use these forms on a routine basis. What does that mean? It means you issue a form no matter what the situation is. Oh, it's a medically necessary stay, issue a form. Now, keep in mind there are some basic things that will go with that, like what are your rights if we should choose to discharge you. That's a different type of situation, and we'll talk about those as we get to the form. So you can't just issue something saying we're not going to cover this service while you're sitting inpatient, or just in case we don't start covering something. They'll have to use it very specifically, and that's a form as well. It's a different type of form. You're going to stay inpatient, but this one service is not medically necessary anymore. Different type of form. You must provide a copy to the patient, and you must allow the patient time to consider the options. In other words, if the patient needs time to think about it, their family needs time to consider it, you do have to allow them that time. Walk away. Once you've explained it, do they have questions? Can you answer all of them? If not, can you refer them to 1-800-MEDICARE and allow them or their family or whoever is representing them to make that phone call so that they have a further or clarification? Now, someone asked, why would you want to refer them to 1-800-MEDICARE? And as I just said, it's anytime you are unclear as to a Medicare coverage question or will Medicare consider that medically necessary based on the following. You have a belief they won't, but you're not necessarily the expert in Medicare. And that's what 1-800-MEDICARE is for the patient. Now, could you call 1-800-MEDICARE? Only if the patient is with you. That was another question. If the patient's with you and you want to help them, sure, you can dial 1-800-Medicare. You can help the patient through that process. That's fine. If the patient's not with you, then you would call your Medicare Administrative Contractor or MAC for help. Now, we are your Medicare Administrative Contractor for J5 and J8, so I wanted to make that as clear as possible. Again, yes, you can call 1-800-Medicare with the patient. All right. Let's talk about signatures for a little while. So you're going to present each one of the forms. You're going to make sure it's clear to the patient what the form is for, why you're presenting it, that they understand all those great questions that you're getting. Then someone is required to sign it. Now, keep in mind, this is not a financial signature. This is a requirement that says, I received this form and I understand it and it was explained. It's not a financial requirement. This is why sometimes people will refuse to sign it. We'll talk more about that under some signature considerations in the next slide. But let's say that we're going to sign it, it's all good. Who can sign it? First, yes, the patient can sign for themselves. How many of you, though, have had that patient where they really can't sign for themselves? Could be a mental health reason or a variety of other complicating reasons, and someone else is there with them and they explain it to them. That's fine. So a spouse. Key thing here, if they are legally separated, the spouse cannot sign it for them. Now, that is a state-issued legal separation. Could an adult child? Absolutely. Adult being the keyword, 18 and over. Parent? Sure. Adult sibling? Sure. Close friend? Sure. Authorized representative? Absolutely. Now, when you use an authorized representative, you do need to write rep or representative just to indicate that this is who it is. A lot of times, the legal system isn't sure who that person is or why you're using them. So you want to make sure that's on there. Now, keep in mind, if this person does have a medical power of attorney, they can sign as well. That is part of a legal representative system, and you want to make sure that that's there. So do they necessarily have to be that legal versus an authorized? Now, authorized is authorized to act on their behalf. It's authorized to act on the patient's behalf. So no, not necessarily do they have to be a legal representative. It is a decision. Keep in mind, yes, they could if they especially have that right, but they don't have to be. Because this is an acknowledgement that the form was given and explained. That's why any of these people can do that without necessarily having to have the legal right to do that. And hopefully I explained that well enough. So when I'm talking about this acknowledgement, yes, a legal representative can, but these are the other people that Medicare would consider because this is not a financial liability. This is simply it was presented and explained. Also, I'll give you a clue or a hint. I always recommend that if it's not the patient, indicate who it is. This could be a spouse, a child, any of those types of things, adult siblings. So my sister signed for me. We don't have the same last name. She's married. She has a different last name. People might not necessarily recognize that she's my sister based on name alone. So we always recommend that as a tip just for you to consider when you do this. All right, so that's signatures. But of course, signatures aren't just clear, cut, and dry. So we do have some signature considerations that we definitely have to talk about. How many of you have ever been with a patient and they decide, oh, nope, I don't want to do this, or I don't want that, or I don't want this? Can they change their mind? And the answer is yes. Medicare says, yes, go ahead and let them change their minds. That's fine. Here's what we need you to do. Don't write a new form. Remember, this signature and date that they had won't be before this happened. So it couldn't be before the discharge. It couldn't meet all those requirements, and we'll talk about those in just a little while. On the other hand, what you should do is note it on the original form. Please do that. And this will then allow them to have a copy of it with the notation and all of that. You can note it on the original form. You can send it for a signature with a copy for themselves and then resend it again. However you want to do that. Emailing is considered sending. Faxing is considered sending. People have asked us those questions. So you want to revise the claim though. And this is some of the coding that goes in the claim. So did you use the occurrence code or the span codes or any of those types of things, including a modifier? And so you may need to actually go back into the system and to revise the claim to indicate this, just so you're aware. Now, are there times when a patient isn't willing to sign and their representative, the person that's with them, isn't willing to sign? They also say, hey, I don't have that state legal right. I'm just not willing to take that. That's okay. Medicare says as long as you've properly completed and presented the form and you've indicated the refusal on the original form, you sign and date it, as the presenter and the person that had their refusal given to you, that's okay. Now we're going to act like it's a regular form. You did do your job. You still want to give them a copy. You don't want to change any of that. WPS is going to give you a recommendation. And if you notice on the refusal side, the right side, the second main bullet says may list a witness. This is a recommendation coming from your MAC. It's not a CMS requirement. We recommend this just in case there's ever a legal question that comes up. It just adds more weight to say the patient did this. Someone asked in a question, I think they saw this, and they said, does the witness have to hear the full explanation and that they understood? Not from our perspective, from what we understand and from what we've seen in the legal perspective, no. What they need to hear is, I'm not willing to sign that. That's what they need to hear. So we want to make sure that you're aware of that. So the witness is just saying, hey, I'm not willing to sign that. Okay, that's fine. Then have them witness it, give them a signature and a date just like they would above. Okay. If it's not medically necessary and it's not needed, Medicare does state, now this is a CMS statement, not a WPS statement, you can consider refusing the item or service. It's not medically necessary, therefore, why would you want to do that? However, before you do that, you do need to consider any negative consequences to the patient's health and safety. Safety being a concern here. So what if there's something happening at home and though it's not medically necessary for them to say there's a safety concern, or there's other issues. Also keep in mind there may be results from a civil liability case that has nothing to do with Medicare. Just because the Medicare rule says certain things, this is what's going to happen with that. So hopefully you're aware of all those different things. I want to make it very clear, if they refuse to sign, just document it. Please make sure you do that. All right. Leave those considerations. We're going to move on to patient liability. Now, if this is properly signed, you can, and given, which means presented, explained, properly signed, time to call, all of those different things with a proper date, you can actually collect the money from the patient. That's fine. You can collect before they leave. That's fine too. Here's what Medicare states. If Medicare does pay, Medicare sends you something, Medicare makes a payment on it, it's billed to Medicare, there's something else going on, and this can happen when there's a quality improvement organization or a QIO review. We'll talk more about that. It's the BCC QIO, and they're going to look at this and if the patient requests it. So that will sometimes happen. Now, what happens? One, Medicare says, if we send you money, you have 30 days from the remit notice to get the patient their money back. Someone asked with this, do they have to give the patient the full amount back? Could they withhold the amount that Medicare would state is the patient deductible or copay for that stay? And yes, you do have the right to keep that amount. Medicare is not saying give them all of that. Notice it says if Medicare pays, a Medicare payment does not incorporate the deductible or the copayment amounts. That's automatically going to be removed. And so yes, you have the right to keep that. If it is done through an appeal, you have 15 days to return this money. So there's a very big time frame difference there. 15 days doesn't seem like a lot until you go to issue a check, until you try to get someone money back, and then it can be a big time frame. So we wanted to make you aware of that yes, you can collect up front. That was a question that was asked. There's no problem with that. However, if it does have to be submitted to Medicare and Medicare does determine that it needs to be paid, then we will issue you a payment removing patient liability, and then you must complete the refund based on that. Hopefully that answers the question. If not, throw that back in chat. I'll get you some more information. The next question that we actually got, I put in here to answer this because we get this one commonly, and then I did, of course, get it during the registration process, is where does this information come from and why are we even talking about it? And you know, what happens with this? So keep in mind, this comes from the Medicare Claims Processing Manual. It's part of the Internet-Only Manuals, or the IOMs. These are the day-to-day operating instructions for CMS. So the Medicare Claims Processing Manual actually has a full section that talks about these different forms, the reasons to give these notices, when you must present them, and how they must be presented. This is where we get information that helps understand all of this that I've given you so far, but also going to get into the details that we're going to come to next. I did have a specific question, and when the question was if I could show you where to find this, I will do that now versus coming back to it, though I probably will show you again in the end if I don't. So first of all, you're going to go to the CMS website, cms.gov. On the CMS website, you're going to go to the term Medicare. That's what we're talking about here. Inside Medicare, a lot of people, and in particular, they mentioned the coverage section. It's not where it's located, and I think that's where people were confused and that asked the question. It's regulations and guidance, and it's manuals. Once you're inside manuals, you're going to go to the internet-only manuals. Remember, I told you this is one of them. Once you're inside the internet-only manuals, all of your benefits are laid out in 100-02. This will help you, the Medicare Benefit Policy Manual. This will help you determine whether Medicare considers things medically necessary, things to look at. Keep in mind, I said help you. It's not the standing item alone. You do have to look at the doctor's reasons and rationales and medical notes and all that fun stuff, but they'll give you some more information. On the other hand, this section is actually in the Medicare Claims Processing Manual, and that's 100-04. Again, Medicare Claims Processing Manual. This reference was back on your slide for you. And then if you open it up, you got to scroll down and down and down some more, and you're going to come to Chapter 30. And Chapter 30 is Financial Liability Protections. What this is a part of a implementation of regulations that were put in place. And what it does is helps people understand, and people being the Medicare beneficiaries and patients understand what they're going to owe you. So that's what this limitation on liability under where Medicare claims are denied. That's the law, the actual section 1879 of the Social Security Act. That's why it's here. Now, I'm not going to scroll all the way through this, but I will let you know that it is here. And in particular, we're looking at 240. And you can see there's a lot of sections in this, right? So we got to get out of this, scroll down to that. Look away if you don't like my fast scroll. Pre-admission hospitals. This is what we're talking about right here. And it'll walk you through all the notices, the information. That's where we're getting our guidance from. So keep in mind, this does incorporate a lot of pieces of information. It will refer you to other sections of the IOM, other manuals. It will refer you to the Social Security Act. It's going to refer you to the Code of Federal Regulations. There's a lot of different places to go. That's why we have different resources and things to try to help you out. All right. So the next question that I actually got is going to keep me right here on this website, because the next question was, where do I locate these forms and how do I find them? I'm going to use a little bit of a different method and then I'll explain it also. If you look up here, you'll see CMS website. And if you click that, it will open a link, except it's not turning blue and opening. So I've created this for you so that you can do this throughout the presentation. So this previous slide, there was one there. So here, I've opened up the Medicare website. This should look familiar to you. And what you want to do is open it up, and you're going to read through the different coverage, payments, all those different types of things. What are you looking for? On the very bottom, oops, sorry. You're looking for forms and notices. Now, it's 4 from the bottom, so it's going to be down there. Inside there, you're looking for the Beneficiary Notice Initiative. Okay, this is part of the regulations that I just read to you. This is what it's actually called when CMS references it, that we're going to tell them about tonight. Now, keep in mind, there's more than just the hospital issued notices in here. And that's why we have a left-hand navigation, which will explain all the different notices. And there is the HINN for you, the HINNs right here. If we up those 4, we'll get more information, find out about downloading them here, and you can do all of those different downloads. So hopefully that helps you understand where you're going to get these pieces of information and why we're going to look at these different forms. When we look at the different forms, each one is spelled out and there is a section of the manual. And let me open this up for you here. So what I'm doing is just downloading it. I'm going to keep talking while I do that. What we're doing is going to open up our application pieces here. And this is important because inside here, you will have the different forms, but you're going to have the different manual references as well. And so this is a really nice place to come if you're looking for all the information without having to go the long way that I showed you. Sorry, my computer is not acting like this has never been opened before. I'm not sure what's going on there. But here's your instructions for each one of the 4 forms. And then here are the actual model forms. So one is in a PDF and one is in a Word doc. They look the same. They're just a little different format, but you're welcome to open up any of these. This is what I'm going to walk you through. I'll walk you through each one of the forms with little instructions to go with it. you can go ahead and open these up if this will help you more. It's perfectly fine to do that. All right, let's move on. And what we're going to do now is start with the first form. Now, the first form is HINN1. Put them in this order because they go in numerical order. So this is the hospital admission issue notice of non-coverage. If you want to use this form, there's a couple of key things you have to keep in mind, and that's what we're going to start with. One thing that this form is for is when an entire stay is non-covered. So it's an entire stay. It's never going to be covered. It's not going to make the coverage criteria. Even if they have medically necessary days left, like, yes, we could cover it in this period, only we're not going to because it's not medically necessary. That's what we're using this one for. Okay. Let's go ahead and move on. Okay, so issued to the patient when it's in a non-covered hospital or a swing bed. Now, a couple people did ask, what's this swing bed thing? This is where you would use a hospital bed as a skilled nursing facility service. So that's the terminology for it. It's a hospital, but it's being used as a skilled nursing facility bed. You must be certified to do so, and you're certified to have both. I'm believing that the person that asked me this must not be swing bed certified, so they probably just weren't familiar with the term, and that's what it means. So when we look at this, you'll see the services are not reasonable and necessary. R/N, that's what reasonable and necessary stands for. So in other words, they could be safely provided in another setting. The patient doesn't need them for their condition today. For whatever reason, Medicare is not going to find them medically reasonable and necessary. And it's going to be the entire stay. An example that someone asked me about was a patient that they had that came in. Did they need to be in the hospital? They did not feel that they did need to be in the hospital for medical reasons. Instead, it was a safety issue. And so they felt like if they sent them home, it was unsafe an environment. Medicare doesn't necessarily cover for that, but they did have an issue where Medicaid would cover it for within their state. Okay, that's a Medicaid issue, not a Medicare issue. We would still expect you to tell them, hey, this isn't going to be covered by Medicare. Now, keep in mind, you could say, hey, but we can submit this to Medicaid, two different things. Hopefully, I got all of that summarized from that entire paragraph that was sent to me in the question format. So if not, throw that back in chat. I'll get you some more on that. So when we're looking at this, what do you have to do? Prior to issuing, the hospital obtains concurrence from the attending physician, the quality improvement organization. So this is key right here. You want to make sure that you have these decisions, okay? If not, then we're going to go with a different thing. Okay? And if you said, hey, the attending or the admitting physician did not agree, the attending physician did not agree, but my admitting physician does agree, okay, we're good. So we want to make sure we have all of those items in place. The biggest part of this is to remember that the form must be issued before providing any of the non-covered care, before actually admitting. Someone said, could I do this during the admission process? Sure, you could. It's part of what you're admitting them for and part of what you're explaining. So yes, you could. Now, when we talk about hospitals, one of the key things to remember is Medicare doesn't limit these to an acute care hospital or a critical access hospital. They use the term hospital. So if you're talking about any type of a hospital, these could be applicable for you for that purpose. Okay, so we want to make that clear. I should have probably made that clear before in the other ones. Now, what happens if the patient says, I don't know. So as I mentioned, this informs them that the entire stay is their liability. So it's pre-admission from a liability of all services. When do you want to make sure this is billed for? Well, if the admission occurs before 3 p.m. or at 3 p.m., then the beneficiary is liable for services on the date of receipt. If it's going to be after that, the beneficiary will be liable for after the receipt of the notice. So you want to bill Part B for Part B services. And I talked about that, remember? You can still have the inpatient care not be, but the Part B care going to be. So it's very part of making sure you're doing that particular portion. Remember, it's a non-covered stay. It's not medically necessary. Now, does this mean that the patient's automatically going to agree with it? And the answer is no. Part of this form will give them their rights. And this is really why you're presenting this form. Within 3 calendar days after receipt of the notice, or at any point during this stay. So let's say they're doing an elective surgery. Elective surgery. They don't need this surgery. It's not going to be medically necessary, right? But they're going to stay in the hospital because they're doing this elective surgery. Someone said cosmetic surgery would be a great example. Great. Yep, you're going to stay in the hospital 3 days, 4 days after your cosmetic surgery, but Medicare is not going to pay for it because it's cosmetic. The surgery was not paid for to start with. So what if we want to make sure we want to do that, and we want to make sure we're saying, okay, within 3 days, now give them the opportunity to go ahead and ask the questions. You could give it 3 days after the receipt of the notice, right? That's what we're talking about beforehand, or at any point during the stay. So hopefully all of this makes sense. Again, you can issue it at admission at any point during the stay. So we want to make sure you're aware you can issue it at admission. This is the normal time. You could be responsible for a period of services, especially if there was no medical necessity and you didn't issue this, and then you issued it 2 days later. Again, in the cosmetic situation, maybe an example of that. So that's what we want to make you aware of with this one. All right. So again, what does the QIO do? Now, again, this is the Quality Improvement Organization, and they're going to do a review. So upon patient request, they're going to look at it. They're going to determine whether it is. So they're going to determine whether it's reasonable and necessary. Well, how do they do that? They have to ask you for records. And the records they're going to ask you for must be delivered fairly quickly back to them. And when I say fairly quickly, it's normally on the day that they ask and by the end of that business day or the end of the next day. So you want to get them back as quickly as possible. Now they could then, after the review, take 2 days to determine. In the meantime, Medicare may pay for that stay because it's in a QIO determined stay, and you can't discharge them while they're in this QIO stay. Now, on the other hand, there are times this will be done after discharge. Then that's called a late review. It doesn't really apply to anything. You still have to respond back. You still have to do all of that. And you may be able to go back and bill Medicare, but the patient was already discharged. So you need to refund the patient any amount collected. Now, this would be obviously if you collected and they're already gone home or whatever the situation is. Now, again, here's that exception. Don't refund them patient liability amounts. Don't do that. Also, don't refund them for anything not covered by Medicare. So this would be something like a comfort item or something that Medicare says this isn't part of our coverage guidelines. So make sure that you're aware of what is and is not, and you want to make sure you're following those as well. Okay. If it's not reasonable and necessary, then again, it does stand, and the QIO will make them liable as of that specified date, which is the date of notification. So again, during the meantime, you may be able to bill Medicare for that purpose, but it's because there's a determination going on, and that's just part of the process. So hopefully that does make a little bit of sense when the patient does request this. All right. Next one, hospital notice requested review. So this is just some model language for that. I do recommend that you always use it. Please don't take it, hey, I just don't want to do this. Yeah, it's best to get this one out in this format. So when we look at this, what is this one used for? It's when a hospital determines that they're providing non-covered hospital stay bed services. So unlike when they came in and it was not medically necessary, they may have been medically necessary. Now they're going to stay, but it's not medically necessary. Why is it not medically necessary? Well, they could have been safely provided in another setting, such as a skilled nursing facility, such as home health care. So the inpatient level of care is not medically necessary. Okay, again, you can still continue to bill those Part B services. So this one is different than when your stay was just not medically necessary at all. This means I'm going to discharge you. I don't have any, hey, can't find a skilled nursing facility. Hey, there's no home health organization to work for you. This is when it could have been done in another setting. It's just not available. Hopefully that makes sense. So again, if you're going to provide non-covered inpatient bed services that would constitute custodial care, this would be another great example. Now, they may need some nursing care, but at a different level, and you're not a certified swing bed. So in other words, you can't just move them into that swing bed. There's no swing bed, you don't have that as a possibility, then it's going to be at a not reasonable and necessary care for your facility. So you're unable to obtain concurrence from the attending physician. This is key. If you don't have that, you can give them this and letting them know, hey, don't have this. It doesn't mean that we can't discharge you. We do have to discharge you. But the hospital is seeking a quality improvement organization QIO review. What this will do is allow you to ask the QIO, the Quality Improvement Organization, to do a review on reasonable and necessary on behalf of yourself and the patient. What's nice about this is they're going to make the determination on whether or not it will continue to be covered. It is your opportunity to do that. What is your goal? Well, your goal is simply to provide the patient a notice that, hey, I'm going to ask this quality improvement organization, I'm going to ask Medicare to determine whether or not we should continue to cover this because you aren't meeting our reasonable and necessary standards on this inpatient stay. Maybe we don't have any place to send you. Maybe we, whatever the situation is, but in terms of us at this point, we would consider you non-covered for reasonable and necessary, for medically reasonable and necessary. All right. So what do? Hospitals, well, you supply the information to the QIO. That's key. But keep in mind, before you do that, you're going to supply the patient this form. When you supply the information to the QIO, this form must go with it. Send the copy of it with it. Don't send the original form. Sorry, let me say that again. Send a copy. We just want to make sure the QIO knows that you did notify the patient is aware of what's going on, etc. You can supply the information to the QIO by telephone or in writing by close of business the first full day following the request. The information is available on the CMS website. I did show you that website, so it'll also help you get through where to send it to. What is the QIO's job with this one? Again, they must examine the records. So they're going to request the records. You're going to send over the request. They're going to request the records. They have 2 days to make this determination. During that time, you may continue to bill Medicare. That is normal. That's part of the process. Then they will notify, again, the beneficiary of the hospital and the attending physician. The attending physician is notified because they were not originally able to agree or disagree with the discharge. You don't have any idea what's going on. So we want to make sure that this is something that's available to them. They also were not able to say, hey, this patient should stay or not stay when something's unavailable, like an additional facility. So they want to let the physician know. You as the hospital, as the requester, they're responsible for letting you know their decision. And then the beneficiary, they'll let know for the patient liability purposes. So lots going on into that one, and a lot of things happen simultaneously. All right. Oops, sorry, one step too far. The next one is the non-covered services during a covered stay. This is the HINN 11. This one's a little different. This one is used specifically when the patient will remain in a covered Part A stay. In other words, Medicare Part A is still going to cover the services. Only these services aren't going to be covered because they're not medically necessary per Medicare coverage guidelines. Those coverage guidelines are in local coverage determinations or national coverage determinations. In other words, Medicare says, we're not paying for this service today. Here's why. And that's the reason that fits your condition. So therefore, here's what's going on. Okay, these are not for bundled services or integral to payment or treatment services. In other words, without these services, you can't do a form or a portion of another service that is part of a covered stay. That's not what we're talking about. Also, Medicare does have certain services that are components or bundled into other services, and that's part of a fee schedule amount. And you want to make sure you're aware of those, and those services would not meet this as well. Someone asked, and very clearly CMS does state this, but as a hospital, you're choosing not to bill the patient for these not covered services at that time. Do you still need to give them the HIN 11? And the answer is no. If you make that choice as a financial choice for all patients, then don't do that. If you're going to bill any of the patients, then you want to give them this. Now, if you say on an individual basis, this patient comes back and asks for a hardship waiver, that's a financial hardship waiver, which is a legal request. It's a different situation. That's a case-by-case basis. You would still need to do this form, but then on a case-by-case basis, consider whether or not you want to be holding them liable or whether or not you can waive that liability. Again, if I didn't answer that question in a way that you needed me to, please feel free to put it back into the chat. I can get you some more clarification, hopefully, but I wanted to make it as clear as I could. Oops. So with the patient charge, what is the what's going on here? There is no time frame to wait to charge the patient with this one, and that's very clear. The patient can directly have to pay you after giving them the form. Now keep in mind, remember I said they're still inpatient. Does that mean that you could charge them while they're still inpatient for this non-covered service? And the answer is yes. It's a non-covered Medicare service. So we want to make sure you're aware of that. What's your job? Give them this form if you're planning to charge them. If you're not planning to charge them, then there's no need to use this form. You can collect from the point of signing. Here's the thing, if you do not collect at that point, then you do need to inform the patient of the intent to collect before discharge. So hopefully that makes sense. While you can collect at the point of signing, let's say they're in for another 3 weeks, 2 weeks, 1 week, whatever the situation is, you hand them the form and say, hey, but before we discharge you, we will begin to collect for this service. And here's what that means. So hopefully that does make sense. So unlike the other form where we've talked a lot about it, and I've talked quite a bit about it going to the QIO, this is under the Medicare Administrative Contractor Review. Now again, this is very specifically unless a patient or the MAC goes to the QIO. So the patient could ask the QIO, again, it's the same referral process, information is spelled out to them, but otherwise the MAC would review this. The MAC reviews in the following cases: the patient's or representative's complaint. Well, they would complain to the QIO, or they would let us know. We could then ask for medical records to see whether or not this should have happened. Development of a related claim. People have asked us about that and when would this occur? One of the times this occurs is when there's a claim submitted by another provider for a service and the patient's saying, hey, this wasn't this or this wasn't that, this isn't covered because, then we could develop to make sure that that was all given properly. And that can be also, and that can also include lab tests or other types of tests that aren't covered because of Medicare coverage criteria, LCDs and NCDs. So it was provided, but it's not going to be covered. Therefore, they can't bill the hospital and the hospital can't bill Medicare. On the other hand, they do have to bill the patient, and that's when this could be developed on. Also, there are times when the QIO will refer to us and we will have to then look at it and start following the case. So that's how we get these reviews. It's not typically something where you send something to us and say, hey, can you review this and can you look at this and can you do the following? That's really not how it works exactly. So hopefully that makes sense to everybody. The next one and the last form is the non-covered continual stays. So what this form is used for is to say, hey, beneficiary remains in the hospital beyond the hospital determined discharge date. This is where they want to stay. They don't want to go. For whatever reason, they're choosing to stay. Somebody asked me if this is a common form that we see. The answer is no, it's not that common, but I don't want to make it seem like it's never happened. It's not out there. Some hospitals see this more than others. It really just depends on your type of hospital, your patient population, etc. So you want to do that. When you note that you're giving this form, you want to also make sure that you're giving the important message for Medicare. This is another form that CMS requires to go with it. So we'll talk about these two in conjunction with each other. Okay. So patient remains in the hospital. Can they file the QIO request? Absolutely. The patient does not agree that they should be discharged. What they will do is timely file the QIO request. Now this is the next day, within the next day they file. This will stop the discharge. It doesn't necessarily stop them owing the money because that isn't determined until after the QIO completes the review, 2 days to do that. So if they say, no, this should not have happened, you should be discharged, then the patient's liable. If on the other hand, they say, no, Medicare, we will be liable, we'll take that liability, then the hospital bills Medicare. Hopefully that makes sense. So how does this work? Timely QIO review not requested. So we've had a couple questions come in on this. And what happened was the patient was actually discharged. Then they went back and tried to request the QIO review, which is fine. The QIO review said, no, they should have been able to stay. So how does that work? That will make it so that the entire stay that they were there was covered for a longer period of time. Now, keep in mind, by timely, they're just saying it's midnight. That's the day of. So this particular example that was given to me was 6 days later. They were in the hospital for 6 days. They didn't leave. They refused to leave. At that point, the patient finally filed a QIO request. Again, they do have the right to do that, and that is their decision. And by doing that, the QIO then looked at it and said, okay, You didn't file this timely. There's a period of time where this is happening and this is happening. Here's the decision. By the way, it's going to be in the day that the hospital determined you should have been discharged because you shouldn't have a need to stay. Okay. All right. Sorry, I'm stuck. The IM use. Now, this is the important message from Medicare use. This is another form you have to give. And this one just says, hey, here's your rights as a hospital inpatient. Here's your discharge appeal rights. It's explaining all of those steps and items that they need to understand, and it's why we're giving it to them. It does give them those appeal rights, and you can see that right here on this slide and kind of in the bottom part. Your rights as a hospital inpatient, but then also your rights to appeal your hospital discharge. And that's the key thing that we're looking for. It explains time frames, who does the appeals, all of those different things. So that's why you have to give them this, okay? And again, we talked about this a little bit more, but it is the rights, it is the discharge appeal rights. This must be issued to all Medicare beneficiaries upon admission and discharge. So, and discharge. This includes beneficiaries with Medicare as a secondary payer or a Medicare Advantage plan. Did you catch that? Or a Medicare Advantage plan. This is the only form that CMS strictly says must be given for Medicare Advantage. If there's a different one, take a look at it. They'll give you the instructions out there. Okay. Please note, this form does not apply to swing beds or custodial beds. In other words, they're in a swing bed. That's a different type of situation. That is a skilled nursing facility form. It's separate. If the service was never reasonable and necessary to start with, think all the way back to the first one that you gave them. You don't have to give them this because we've already determined that. This form also does not apply when their benefits exhaust. What that means is that Medicare pays a certain number of days, and it's 90 during a benefit period. If there's a 60-day lapse, we'll restart those 90 inpatient days. But the 60-day lapse can be no inpatient care at any type of facility, right? So let's say that they don't have a 60-day lapse. Okay, well, they've gone their 90 days. They've already used their extra days, which is 60 extra days, lifetime reserve days. They don't have any more benefits. This is not the form to give that. That's a benefit exhaust. You're still in a covered Part A stay. They're just going to be liable for it because there's no more days. Okay. Also, for services covered under Part B, this doesn't apply to them. We'll talk more about that because services covered under Part B are not part of the hospital notices. They're part of the ABN, Advanced Beneficiary Notice of Non-Coverage. That's their Part B form. Okay. So when you're giving this, you want to make sure you're giving it the right time. So remember I said admission and discharge. This form, initial, issued within 2 calendar days of admission, can be pre-admission. So this could be up to 7 days. Again, we're talking about patients coming in for a scheduled surgery, medically necessary. We want to let them know what their rights and stuff are. Must be signed by a patient or the representative, and you're given a copy. Again, this one just says, here's your rights. That's what you're doing here. The follow-up copy, issued no more than 2 calendar days before discharge, but not less than 4 calendar days prior to discharge. So making sure you're within that time frame. 2 calendar days before discharge, 4 hours before discharge. Not required if the initial copy was given within 2 calendar days. Well, that makes sense. If you gave them this copy, they were only in for a couple of days. Now we don't need to give them a second copy. The follow-up copy does not require a signature because you do have it on the original. This is just to remind them of their rights. And that's how we like to say the follow-up copy, to remind them of their rights. Okay. Making sure that we're well aware of which one to use there. All right, somebody asked specifically about hospital-to-hospital transfers with the important Medicare message. And so the transferring hospital, you don't need to give a follow-up copy. You don't need to do this. The receiving hospital delivers their initial copy within 2 days. And it's because each one has a little bit of different rights and situations and time frames. So we want to make sure the follow-up, the transferring, you're still in a medically necessary stay. You're just leaving this stay and you're going to a receiving hospital. So hopefully that makes sense there. Oops, too far. Get expedited review requests. These can happen. The beneficiary must submit the request to the QIO by telephone or in writing no later than midnight on the day of discharge. Now that's because Medicare will continue to stay, so it has to come in on the day of discharge. Okay, once it comes in, they don't leave the hospital. Okay, because if they've left the hospital, now it's going to be considered a different situation. They are not liable for the time of the expedited appeal. Keep in mind that's that 2 days to get everything together and to do all those different things. If it's what's called an untimely request, which means they're already discharged, they didn't file within that time frame, then they will have an expedited review at any time. They can ask for it. The beneficiary is no longer in the hospital. The review request must be within 30 calendar days of the discharge. That's why it's a little bit of a weird term when they say untimely. It's just within 30 calendar days of the discharge. However, they must provide a good cause if they're outside of that 30 days. So why didn't you do this within 30 days? What happened? Okay. Beneficiary is not protected from liability during the untimely expedited review. In other words, there's a period of time when they could have other things going on. They could be seeing outside services, all of that. It doesn't protect them from any of those financial liabilities. There's expedited review does not do that. It does not mean you need to readmit them. That's not what it's saying. If they do it timely, which is before midnight on the day of discharge and before being discharged, that's what we're looking for, okay? So if this happens, the QIO must notify the hospital of the beneficiary's request for an expedited review. They must then receive and examine the records. They must determine if the hospital stay will be considered valid. Now, the notice being valid, the notice being delivered means, is the hospital stay still going to be covered? Now, one of the key things, and the reason I put this on here is because they do have to talk to the patient or their representative and the hospital. This means that they must be available to do this. We had someone ask us about that. They said, what if the patient's not? Well, then hopefully someone else who represents them, such as a spouse or significant other who has legal representation over them, can do that, because they do have to solicit the review. Also, we had someone who sent it in and the person left for vacation that evening. Well, so when the QIO went to do it, they called the person. They actually spent 2 weeks trying to get a hold of them. On the second day of the expedited review, they just upheld it. They said, no, this isn't right. The hospital is going to be financially liable for this, whether Medicare determines it medically necessary or not, because you should have been responsible and we should have had someone to contact. So that was just a what-off situation that happened and just kind of a cautionary tale for you guys. Once they make the decision, they are responsible for notifying the beneficiary hospital and physician of their determination. Again, if this was filed timely, they would still be in the hospital, and therefore we would want the physician to know they're staying in the hospital along with the patient in the hospital to continue to bill Medicare. Okay. So what's the hospital's job? Deliver the form. Well, that makes sense. Provide information to the QIO by following noon. So the date that this is sent in, the QIO will request information. The day that you get the request, you have till noon the following day to get that requested information to them. Provide documentation to the patient if requested. So what they request, it's up to them to provide whatever they're asking for, whatever they want. So if the patient documentation is needed, they need to get that. Okay. Now, the reason that happens is sometimes the QIO asks the patient for certain things, except the hospital has that. So then you've got to give it to the patient to give back to the QIO or send it directly to the QIO. That's what I'm talking about there. So hopefully that little bit of a weaving tail back and forth does make it understandable. All right. So what does the QIO do? Well, they got to act. They have to provide a review. They will determine if it is reasonable and necessary. Now, if it's determined reasonable and necessary, that's when they'll say, nope, just the patient's responsibility, the coinsurance or copay and deductible must be met. Keep in mind, this is a covered Part A stay, so therefore a lot of times it's just going to be a flat copay amount, but that's what they're going to assign. Then they'll tell the MAC, hey, you must bill it, or hey, you must pay it if we need to pay it. So if we already have a denied claim or something happens, we can actually get instruction from them as well. However, typically it's how you bill the claim into us that will change this. And when you go into the system to adjust the claim, this can happen. They can also determine it's not reasonable and necessary, in which case they'll notify the patient that they will become liable. Once that happens, patient liability starts at noon the day after the QIO notifies them. So it's important to make sure that they have gotten this notification. It's the QIO's job to make sure they have all of the information needed. Now, if the patient still disagrees, there is a whole other process they can do. It's the QIO's responsibility to provide that information to them. Okay, so I want to make sure that's about as clear. They do have to notify this independent review entity, and they have up to 72 hours to do that. All right. Brings us to a few answers we're going to get through. We can get through. I'll respond to the rest of them via email. So what HINs are used for Part C? Again, only the HIN 10 is for both. The rest of them are not. Make sure that you're aware of that. I didn't talk about that when I did the HINN 10, but that is the only one that is. This is part of a Medicare Advanced Written Notice of non-coverage. It's an available resource to you. It's on the bottom of page 4. What if the patient family refuses to sign? Can 2 witnesses sign? We did talk about that. That is possible, and you want to make sure you're doing that. Are facilities required to provide HINs? Are there any exceptions, such as a nonprofit facility? And there's not. As long as it's got the hospital, then yes, they're required to do it. It doesn't matter what type of hospital it is. How to correctly bill these. As I stated, this is not a billing course. This was to go over the individual notices and to talk about those notices and to get you that information. So I'm not going to cover all of the different ins and outs of billing. That's way too much for this course. I do want to just take a few moments, maybe run a couple minutes over here. Leanne, do I have any questions?
Yes, we have a couple. We have several. So the first one is, do you also use these forms in a psychiatric hospital, freestanding, not part of another hospital?
So a psychiatric hospital is still considered a hospital on Medicare, and yes, you can still use these forms and should use these forms if the conditions are met for that psychiatric patient.
All right, next question. How do we know if the stay is going to be paid or not upon admission?
At the time of admission, what you want to look at is what is the admitting reason for it? What are they saying about the patient? What is the documentation that helps with that admission? So it's really going to be a coverage criteria or a documentation issue, I guess, is also another way of saying it, and whether or not you believe that say should be medically necessary. Sometimes also utilization review board is used. So there's a variety of different factors that can happen that way.
All right, next question is, what if there is no appropriate place that will accept patient for discharge? Patient can go to skilled nursing facility, but no skilled nursing facility will accept the patient. Can we still start financial responsibility the next day?
Yes, because according to Medicare rules, the patient actually has 30 days to enter into a skilled nursing facility, so they could be discharged home for a period of time under home health care or under a variety of other types of care. If it's not medically necessary at the level of care you're providing, then they do not need to stay. Now, that would be pending, of course, that they're not a swing bed situation or other things like that. So yes, this could be given.
All right, we do have 4 more, Tom. So the next question is, would the HIN 12 apply when the patient doesn't want to be discharged to stay, to say the only nursing home available or SNF available?
As long as they're requesting that they stay in your hospital and it's not medically necessary and you're like, oh, okay, then yes, it would. And that could be for whatever reason. The patients can use a variety of different reasons that they have for that. But remember also they do have 30 days available where they could be discharged into a different type, even a home setting. So yes, it would apply.
Next question is, do you also give this to a patient on discharge?
I'm not really sure at which point I was at with that question. I'm going to assume it was the hospital non-covered continued stay, and yes, you do. And then you would also give them the Medicare notice also. So I'm not really sure if I did answer that correctly. Let me know, but I think that's what you were probably talking about.
Okay, the next question is, so you are saying that if a psychiatric patient has no more coverage days, that we do not have to give this upon discharge?
Yeah, that's a different situation. That's a utilization or a benefits exhaust. Complete benefits exhaust. That's a different situation. It's still medically necessary for them to stay with you. It's just that Medicare's not going to pay for it anymore. That's a benefit exhaust, and you bill that claim differently as a benefit exhaust claim. So it's different. It's still saying it's medically necessary, and that's what this is, to tell them it's not medically necessary. It's not to tell them their benefits exhausted. In other words, they just don't have any more coverage under Medicare. Two different situations.
All right, last question that we have. QIO process is only for straight Medicare and not Medicare Advantage plans.
I'm not sure about that. We don't work for the QIO. We know that it is for fee for service or straight Medicare, traditional Medicare, whatever you want to call us. Yes, that is where it would fit into. So I don't know for sure if Medicare Advantage plans are underneath there. My understanding is no, but I can't say that with 100% confidence because I don't work in that area. That's it for me, y'all. Thanks for listening. I would encourage you to provide feedback on the survey. It's really important that I get that feedback. Remember, I do want what I did well, what I didn't do well, and if you thought the PowerPoint was good, bad, or ugly, whatever you thought there, give it to me. Don't forget those topics. I need those to build future education for you. They do not have to be related to HINNs, though. They could be related to anything. Take a look at our live events page and our encore page, as well as our YouTube playlist. Make sure you have the information you need from there. So on behalf of myself, Leanne, all of Provider Outreach and Education, thanks for participating today. I look forward to your survey comments, and I hope that you'll join us in future education. You may now disconnect.